145. You are Nicholas Kiru, Ali, and then David Kibiagon Mutai.
In case you want to determine any candidate, then you now have 209 divided by
209 977 divided by
226
226
641.
Wait a little, second last. Oh.
My Lords, the results declared by the returning officer of the presidential election for this county, you've seen the original form being stuck on the wall, being displayed as the law requires, is different. In fact, most of the candidates end up losing the votes they garnered, including the president-elect. My Lords, again it is my submission that if these results were transmitted electronically as the law required and there was a change, the people who voted in this county, the political party agents, would ask for an explanation for the difference. My Lord, it is my humble submission that those two counties, you do not have the result that was declared at the county tallying hall. The results you have are not legitimate. They are not accurate. My Lords, and it's not just the county. I will refer back to the audiovisual recording in the affidavit of Anthony Mathenge. In Kieni constituency, and we've done a breakdown for the court at page 25 of our submissions. The results declared by the county tallying officer are not the results. The results declared at the county tallying center for that constituency are not the results that were declared in the national tallying center. In Othaya constituency, the president-elect garnered 42,431 votes. Those were the results declared at the county. In the National Tallying Center, he had 42,957, 500. It's a small result. But my Lord, when you have 291 constituencies and you give a candidate only 100 more, the declaration of the president-elect would not look the way it does today. Nyeri Town constituency. When the county tallying officer left the county tallying hall after announcing the results in public, the president-elect had 53,253. The results that were declared and published on 9th of March 2013, he has 55,726. An election that is vitiated by such manifest irregularities does not meet the test of validity. irrespective of the result. My lords, the forms before you do not reflect the results announced at the county tallying hall. Form 36. And this massaging of results, if you can call it that, because I will, that is massaging of results, is reflected in the final declaration of results, where the IEBC will stand and tell you that there were 2 registers, 36,300 in a special register and 12,330 and 28. Let me give you the exact figure according to their results. 12,330. My lords, it is my humble submission that when you have even the register of voters appearing in the final declaration different in the Form 36, you have to ask yourself whether this is the bargain we made, whether this is a bargain the people of Kenya made with the IEBC. My humble submission that this court should not shut its eyes to these irregularities. This court should not take a calculator first. This court must ask itself, and I will go back, what does simple mean? What does verifiable mean? What does accurate mean? What does accountability mean? What is free, fair, and transparent? What is valid? Because for something to be valid, it must be legally sound. This is not. What you have seen is not. What you see in the register of voters is not. There's only one conclusion that this court should reach, and I will pray on behalf of the petitioners that you so find. This election is not valid. The presidential election was not valid. My lords, I will rely on the other evidence in our petition. I will also rely on the 4 other affidavits, which also have audio-visual recordings that have not been challenged, showing irregularities in the conduct of these elections. We will also rely on our submissions and our authorities. My lords, I was directed to provide you with only an executive summary of the authorities we'll be relying on, and not the large bundle that I had produced, and I shall do so. And we'll rely on that authority. My lords, you will find in our bundle of authorities a decision by the Supreme Court in India A.C. Jose versus Sivan Pillai and others. A summary is at page 32 of our submissions. In this case, the Electoral Commission decided to use electronic voting machines at 50 polling stations out of 84 polling stations. And the Electoral Commission argued that it had a power under the regulations to exercise discretion in the methods used in voting and elections. The court in this matter held that the Electoral Commission only has a discretion to pass any orders in respect of the conduct of elections where there is no law or constitution governing that matter. It is not an imperium. It actually says no one is an imperium in imperio in our constitutional order. The IEBC is subject to our laws and cannot pass orders or conduct the election in the manner it deems fit. It cannot state that when we transmit results electronically in 44% of the polling stations, that was a test. The transmission of our results was manual, the tallying was manual. No, no. Only Parliament can do that. They can only say that 44% is good enough when they have discretion to say that. It is my humble submission, my Lord, that you allow the petition with cause and in doing so, it is my humble submission that this court will be upholding the Constitution and the laws of Kenya. That is all, my lords.
My lords, perhaps before we corroborate the document, we were served with a document entitled Petition and Written Submissions during the brief adjournment the court took between 2 and 2:30. My lords, at the end of that document, there is a document entitled Petitioner's Further Written Submissions. The last part of the document is not paginated. It states findings from an analysis of Form 34s. My lords, the document is dated the 27th day of May 2013. It is unsigned. My lords, that document is not a submission. It is evidence, and we object to it being annexed as part of the submission.
We'll have to have rules on interjections during the time of other counsel because it eats into our time. And I do believe that when we have set out a schedule as we have, the proper thing is for counsel to wait until their turn and raise all the issues. After all, this is Supreme Court. It is not a jury trial. So your lordships will be able to take it in your stead when the matters are raised at the proper time.
Yeah, I thought that actually that's what we ordered when Senior Counsel Gatia raised that issue. So Mr. Nyamondi took us by surprise.
Thank you.
So, but thankfully seated. So please continue.
You would wish me to start now or have an earlier break as we have an extended sitting, because I see it is only 12 minutes to the time you scheduled for your break.
Okay.
Yes, thank you.
Yeah, thank you.
So we resume at 15:15 or 20:15, whichever is convenient to you.
No.
No, because that will eat into our time.
Judges, 30 minutes, right? It's just 30 minutes. The break. Okay, it's 4:20.
4:20.
4:20.
Thank you.